from the early 2000s, a significant level of labour market and workplace flexibility appeared, and firms have had greater autonomy from both state regulation and from higher levels of collective bargaining. And as you can see, oh, it's gone back. As you can see from the next slide here, from 2008, we saw an acceleration of reforms on union representativeness rules, for example, and a decentralization of collective bargaining, which both Elodie and Arno have written extensively about. At the same time, we've seen this dense network of firm level and firm specific institutions for bargaining, consultation and representation, which have spread widely through French workplaces. The reforms of 2017, however, went further than previous reforms and included reorganizing the different levels of collective bargaining, reducing the resources available for representative institutions, and reforming the regulation of redundancies, just to name some. And the stated political aims of the reforms around employee representation was to strengthen social dialogue by simplifying, rationalizing, and integrating social dialogue and employee representations better within the firm. So the reforms, for purposes of this presentation, required companies by December 2019, to set up a Comité Social et Économique, which was a new body, right? So it's a completely new body, merging three separate bodies: the Délégué du Personnel, or the Employee Delegate, the DP, the Comité d'Entreprise Council, or the CE, and the Comité d'Hygiène, de Santé et des Conditions de Travail, so the Health and Safety Working Conditions Committee, so the CHSCT. So it's important to note, so why are we talking about this? It's important to note that prior to the reforms, each of these bodies had a high degree of autonomy and access to resources, including the ability to carry out investigations, bring in experts, and have regularly sanctioned meetings with management with minutes recorded, so legally recognized bodies. So overall, the reforms in 2017 form part of this longer term trend in France of state-led decentralization and efforts to rationalize employee representation. So now, what theoretical lenses can we, I should have used that one, sorry. What theoretical lenses can we use to understand these reforms? So first of all, we can look through the theoretical lens of the neoliberalization of employment relations. So Beccara and Howe, they observe this common neoliberal trajectory with convincing narratives and evidence to support the case of an increase in employer discretion. And they show that even in countries like Sweden, where formal institutional decline is not overtly apparent, institutions have converted into new neoliberal functions or have been massively derogated. So the authors identify three broad approaches to institutional change. First, deregulation through changes to legislation, if we look at the case of the UK in the Thatcherite period classically, but also in the UK with the Trade Union Act in 2017. Secondly, the use of derogation without having to formally end or replace existing institutions. So for example, the advent of opening clauses in Germany. And thirdly, for our purposes, significant, institutional conversion, where formal institutional continuity masks a change in the function of institutions so that they become more discretion enhancing institutions. The examples that they use are works councils in France and Germany, where they argue that they are increasingly detached from the wider industrial relations system and tie workers' interests more closely to those of their employers. So as I said, French employment relations is heavily regulated by the state, limiting this employer discretion. But the shift from state regulation to the construction of institutions of bargaining and social dialogue inside the firm was the pathway taken by liberalisation, and the mechanism by which the state has been able to partially withdraw from active regulation of the labour market and permit that flexibility and expanded employer autonomy and influence in managing the firm. So with the reforms of representation, we see further institutional conversion with a change in the role, meaning, practice, and functioning of the institutions. Now, while formally the dual channel system remains formally, running parallel is both this continuity and conversion in representation that arguably leads to more employer discretion. The second theoretical lens is that of industrial democracy. So why industrial democracy? Well, we can talk about the positive role of unions and industrial democracy for political democracy. And we know there is evidence about the mutually reinforcing relationship between work, voice at work and voice in politics, and indirect effects through improvements in work quality and social security. As Colin Crouch has argued in what he calls post-democracy, formal democratic institutions and industrial democracy institutions in particular seem to have lost their decisional powers, where under increased competitive pressure, negotiations become consultations, bargaining becomes concession bargaining, and voice becomes mere expression. And as you can see on the slide, Kaufman highlights four components underscoring industrial democracy. And if we look at the balance of power, we can see, or we know, that institutional power remains superficially robust in many European countries, which can lead to complacency. And without other supports like associational power through membership, institutional status can be fragile. So the weakening of industrial democracy from a broader decline in trade union strength and influence, and from reforms in employee representative institutions in dual channels systems like we see in France. I mean, this has implications for industrial democracy. Okay, to get on to the research. So our research looks at the implementation of the new representative body, so the CSE or the CSE that I mentioned at the beginning. So we looked at this in 7 large companies over an 18-month period during 2020 and 2021, obviously a very particular period. The findings are based on 156 interviews or over 156 interviews with managers, employee representatives, and companies across retail, finance, energy, and pharmaceuticals. And our research fed into the official France strategy evaluation report published in December 2021, as you can see on the slide. So the research being carried out with large companies, obviously this is where organizational complexity is greatest and where these reforms pose or raise the most questions. And the methodology was based on waves of interviews and recurrent interviews with the main central actors of social dialogue, and more targeted interviews to cover the different levels and actors of the dialogue. Now, to the findings, we sort of split the findings into 2 areas, and I will just mainly focus on the first area, on the role and meaning of representative institutions, but obviously there is a lot of overlap. So one first sort of area of findings was around the weak negotiating position of unions and the reduction in the number of representatives. So it's important to think in large companies where we were doing our research, large companies are often known for their sort of benevolent approach to social dialogue. And over time, this has resulted in significant resources being allocated to social dialogue, both in the number of elected representatives and the volume of hours attributed to the roles. So in these companies, the gap between the minimum provided in the law and the existing situation is the greatest. And in the absence of an agreement, the new laws allow management to apply the minimum required by the law, which mean a big reduction in resources for the trade unions and institutions. So the unions talked about being in a weak negotiating position from the outset. So in the absence of an agreement, the employer can just apply the labour code. We are not in a strong position for these negotiations, said one union representative. Secondly, the disappearance of the employee delegate body, so the DP or délégué du personnel, meant that maintaining links with workers to deal with local, daily, individual problems this changed the nature and meaning of individual representation. So previously, the délégué du personnel dealt with individual and collective complaints, but with the merger of these various bodies, these issues were in principle now dealt with by the centralized CSE. But many of the union representatives and managers saw the limits of this approach. On the one hand, with the centralization of the bodies, the elected representatives had difficulties maintaining contact with employees, in addition to doing their work within the CSE. But on the other hand, dealing with individual complaints during the meetings of the CSE would make meetings considerably more time-consuming. So agreements on the CSE and management interviews were keen to stress that individual issues must not form part of the work of the CSE. So in one agreement, it is agreed to create local representatives in establishment, but their implementation must avoid clogging up the CSE with individual problems. So there was a fear of reverting back to the délégué du personnel functioning, as many managers saw this body as time-consuming and inefficient. And management often spoke about it in derogatory terms. So here's one quote, how the disappearance of their sacrosanct DP notebooks, of their famous monthly meetings, was seen more through informal exchanges, where the trade union label no longer appears. We talk from person to person, we don't necessarily formalize things, and we learn to trust each other, so we gain in efficiency. And we don't have a meeting just to say that things are dealt with. Well, in some places, they said to themselves, I'm losing my ability to bully the boss a bit. So that comes from a management rep. So several union representatives brought up that dealing with issues informally meant that there was no record of the issue, and also that the work done by the employee delegates was a way of reporting back to employees and doing outreach work. So that outreach work was lost in the disappearance of the DP role. Now, the legislation does provide for local representatives, so the représentants de proximité, or the RPs. However, the rights and responsibilities attributed to this role are negotiated at company level. So under union representatives in one company said they decided not to introduce these representatives as they had no legal standing or rights. In another company, an ad hoc committee was set up to sort of replace the délégué du personnel and to deal with and sort of filter individual questions from employees. So the majority of companies set up some form of local representatives. Now, just before I move on to some concluding comments, the integration or the abolition of the CHSCT, so the Health and Safety Committee, is undoubtedly one of the most controversial aspects of the 2017 reform. So the legal text transfers all prerogatives of the CHSCT, the former Health and Safety Committee, to the CSE, which must have a Health and Safety Committee under it in establishments with more than 300 employees. But it is then up to the agreements within the firm to determine the powers that the CSE will have to delegate to the new Health and Safety Committee, without being to delegate to it consultative powers and the ability to appoint an expert. So in interviews, both management and union representatives talked about the powers of this institution prior to the reforms, and how this changed the committee in the CSE. So the CHSCT, which was the former Health and Safety Committee, had become a place of struggle. It was a place for blocking for the outcome of cases and for expert opinions, whether justified or not. We really came to the conclusion that we were at the end of a system. Everyone was skeptical until the system was put in place. But in principle, we were rather enthusiastic about seeing the staff representative bodies merging. So that comes from the management side. But from the union side, elected representative side, we also see the limits of the new committee compared to the old committee. It is no longer a body. It has much less power. We have the impression that the employer is much less attentive to a commission than to the former committee. They know it has fewer powers. So for many worker representatives, the transition from the autonomous Health and Safety Committee to the integrated Health and Safety Committee represented a real loss of power. So a couple of comments just before on the second part. Obviously, we saw this general trend for more sort of informal and for grievance or problem solving, and obviously some big words here and big themes, but this general sort of centralization of representation, intensification of the work being done by elected representatives, and a professionalization, a greater professionalization. So our research supports some existing arguments that show a gap between the ambitions of the reforms and the perceptions of the social partners. So unions have felt weakened by the reform process. And as one representative said, whereas before it was a battle of strength to compete for positions sort of between unions, now it's become a battle for life. And management have not unanimously found a simplified social dialogue, which is something I didn't really have time to get into. But the reforms have arguably led to what Beccaro and Howell term institutional conversion, whereby the formal institutional continuity masks a change in the function of these institutions so that they become more discretion enhancing. And as Richard Hyman talks about it, while it's not been a frontal attack on the institutions of worker representation, it has weakened their practical effect and arguably has implications for industrial democracy. But not to okay, 2 minutes. Okay, I see. Oh, I'm gonna finish in a minute. So, but continuity, to finish on a more sort of glass is half full, or to talk about it in sort of more what can be done. We do see continuity and resilience of the dual channel system, despite this institutional conversion, as the reforms do not a priori affect the existence of dual channel representation. And the distinction between union representation and elected representatives is maintained. So the findings are complex and nuanced, and we do see trade unions reinvesting in these new structures and resisting management's attempts at developing a more integrated representative body of social dialogue. So just to show you, I mean, we have, obviously, this is a draft paper, which I'm happy to send to anybody who's interested, but we also have a French language blog on Négociation Collective blog and a conversation piece. And obviously we've got the official, our report that was a French language report that was produced on the research that we did. And I'll leave it there.